Please take notice that decisions of the Metropolitan Government of Nashville and Davidson County Community Oversight Board may be appealed to the Chancery Court of Davidson County for review under a common law writ of cert. Any appeal must be filed within 60 days after entry of a final decision by the board. Any person or entity considering an appeal should consult an attorney to ensure that time and procedural requirements are met. Okay. Is it the microphone that's off or me? It's not being, is that better? Can we get IT to amplify the sound? I don't have an up button.
There's a sound button here.
Yeah.
Does that work at all?
Is that better? No. Sure. Anybody else? You can unmute.
Test for volume. Test for volume.
Okay.
Testing, testing.
So let's start with the approval of the minutes, and I'll take a motion to approve those.
I move to move the minutes last meeting.
That was Michaela who moved and Mr. Hayes seconded. Does anybody have any edits to the minutes? Any edits to the minutes? Any corrections? No. Well, all in favor of approving the minutes, say aye.
Aye.
Any opposed? Thank you. As we still get the microphone situation sorted out, I wanted to, in these chair remarks, I wanted to thank the PRR committee for meeting a couple of weeks ago. I really appreciate you taking the lead on creating a system where we can get through the backlog of cases that we have, and it looks like we'll have the backlog of cases done by the end of the month, next month. So that's looking pretty good. I also wanted to give an update on what we discussed during last week's executive committee meeting. We discussed the still ongoing LPR legislation. While one bill was deferred indefinitely, another will be filed, and that bill will be up for second reading at the same time as the current bill that remains. To explain that a little bit more clearly, Councilmember Johnston's bill was deferred indefinitely, but will be filed again to run concurrently with Councilmember Rosenberg's bill. The executive committee discussed this and what Mnpd is currently doing with the LPR technology. Specifically, the executive committee voted to have me send a letter to Chief Drake inquiring about Mnpd's plan should a bill pass or if no bill passes. What current capabilities, LPR capabilities Mnpd currently has, whether it's on vehicles or in drones, and what policies Mnpd currently has in place with the surveillance technology. I've been working on the letter this week and we'll have it out this week as well. Additionally, the executive committee discussed recommending having an extra meeting dedicated to outstanding proposed resolution reports. Director Fitchard will give us some potential days for that meeting in October. And finally, we voted to expedite a use of force policy advisory report and Dr. Villier will give us an update on that as well as next steps later on in the meeting. So I will hand it over to Director Fitchard for the Executive Director's report. Can you still turn on your microphone? Yeah.
Since we have a lot on our agenda today, I'm going to go through this report pretty quickly. So the NCO office, after consultation with the human resources, and because of the COVID increase in numbers, the staff will be working remotely, but there will always be someone in the office. We have a personnel update. We've completed the community liaison interviews, and we are in the selection process currently. And we also had an administrative assistant position open, and that announcement closed, and so we'll be in the next few weeks interviewing for that position. We continue to have training through NACO's webinars, and, you know, we try to find as much training as we can online, right, because of this the situation with the COVID. And so myself and the research team, we today actually attended the Center for Police and Equities webinar, and it was called Navigating Justice, New Data-Driven Approaches to Public Safety. I attended 2 criminal justice planning meetings in September. Mayor Cooper attended one of the meetings. The discussion centered around jail and COVID data. We have a new board member, Mr. Hamid Abdullah. We appreciate him coming to fill the unexpired term of Dr. Stephanie Kong. His term will expire January 31st, 2024. Board member training, for those who haven't had training, the training that HR declares as mandatory, they have that coming up Tuesday, October the 26th. It is on policies and practices on sexual harassment prevention and diversity and inclusion. We have maybe 5 people who are attending the Citizens Police Academy, the fall session of this police academy. It began yesterday on Monday the 27th. It'll end on Monday, December the 13th, and that's being held at the Hermitage Precinct. Community outreach, we're still working on that, and as soon as we get our community liaison, I think that we have some opportunities to grow that department. Monday, November the 15th, 2021, Edie Fitchard and Dr. Villier will give a presentation to Mnpd's lateral class, which is session 94, and we'll talk about the history of the COB, investigations, mediation, and research. Complaints, we had a total of 8 investigative complaints, as well as 2 non-complaint calls for service. We continue to work on our investigations. One of the things that's happening currently is we have 3 investigators, and we recently, as of today, one of our investigators will be out on FMLA. And so we may find ourselves again in a situation where we don't have the staff to be able to complete the investigations in the way that we want them to be completed. And so later on, we can talk a little bit about what that looks like and how we can expand our department, which of course would be a budget ask. Because if we're down 1 investigator, it kind of can hinder the work that we're doing. And things happen in our personnel in their lives, and we just have to be able to recover from that. Mediation, we talked to the executive director of the Nashville Conflict Resolution Center and also former board member Danita Marsh to discuss mediation referrals, the process, what the reporting looks like, and all the other things that go with mediation to see how that's working for us. We've made several referrals, and we just wanted to get a better understanding of that process and what it looked like, and so they were able to help us through that. And then I'll go into the officer-involved shooting. There was another officer-involved shooting that happened on September the 18th. I was made aware of it, and it happened at the Days Inn near Percy Priest Lake in South Nashville. The assistant director, Mr. Clausey, and investigator Johnson responded to the location, and they were briefed by Mnpd. I was also briefed multiple times by the phone and also when I arrived. The investigator and A.D. Clausey went on to view the body-worn camera footage that same day at headquarters. And then I received some post-shooting radio traffic from Don Aaron a few days later. So that process is working the way that we have agreed to in the MOU. We talked about in our PRR committee meeting, for you all who weren't there, we talked a little bit about, of course, why we have cases that have been hindered, but also we talked about how a process may work. And one of those things is when we get officer-involved shootings, we've been, they're director initiated, and what we've been saying is that those cases are full-fledged investigations. And what I've learned over the last year and a half is that those cases, because TBI is investigating those cases, have, really taken a long time to close those shooting cases. And so what we have, and what I presented to the committee was that a proposal to, instead of doing a full-fledged investigation, because we have to wait 3 months at least, maybe 4 or 5, to even begin to talk to witnesses, I think the best thing to do is to do an audit of those cases. That once TBI turns over that information to us, the best thing for us to do would be to audit their investigation, audit Mnpd's investigation. If in fact, if we find that there's some investigatory things that haven't been completed, we could move forward on that then. So that is something that the committee thought would be helpful in moving our cases forward. And I think that would help us as well. Of course, with that, we still have to have access to the records. So TBI gives those records to the District Attorney General's office, and then we have to get those records from the District Attorney General's office to be able to complete our investigations. Some of the holdup has been within that process, and so we are hoping that we get the records when we request them after TBI's investigation as agreed upon. And so once we figure that out from the Attorney General's office, then I think that we can move forward and close out some of those cases that are outstanding regarding the police shootings. So Mnpd records update. We had some, if you noticed on your complaint log, I think that one of the board members requested a 6-month case review. There was some cases on there that had records that had been, we hadn't received the records in order to move forward on the investigation and to present those to you. And so I talked to Deputy Chief Hagar, and Commander Lara was there as well, in regards to how our team is asking for the records. And so there was some hold up on body-worn camera footage that was supposed to be delivered to us. We filed the paperwork, made the request, and then it was pushed back for several months. And what we found out during that process is that our investigators could be a little bit more deliberate in how they're asking for that information, because if you're asking for 5 or 6 body-worn cameras from officers, they don't know exactly what it is that you need. And so they talked to me a little bit about the manpower it takes to review it and redact the things that have to be redacted and so on and so forth. And so we came up to an agreement that what we would do going forward is, number one, make certain that we're asking deliberately about the information that we need, that it contains in the body-worn camera footage. And then secondly, they offered for us to come to the police headquarters and review the tapes that we need to see. And that way you're able to get exactly what you need, and you don't get footage that you won't ever really need, like officers standing around for an hour, right? Which it takes them, they said, for every 30 minutes of video footage, it takes about 4 hours for them to review it. So I thought it would just be more effective, save on resources as well, if we just send an invite or an email and ask, can we get the body footage on certain things? And they said that they would accommodate us on that. So when that process happens, I'll keep you posted on how that's working. I have to attend a force review hearing tomorrow on one of the shootings that we had from last summer. And so that will go on tomorrow at 9 a.m. And there's also a department head meeting with elected officials and department heads, which is something that we do monthly. And as far as the body-worn camera update, I received a update that said Mnpd should be fully deployed with body-worn cameras on Wednesday, September the 29th. And this also includes body-worn camera footage and in-car cameras to the Metro Park Police. And just one other thing, I wanted to say that in the meeting that we had last month, I wasn't here, but I did talk to you in a previous meeting in regards to Vanderbilt and that MOU. And so I hadn't talked back to the chief of police at Vanderbilt, but I think because I was told recently as of this morning that there was an incident involving an employee of the police department there that OPA would be they were asking OPA to do the investigation. And because of that, I think it's still something that we have to move forward on and get answers in regards to how we will work together with Mnpd. I don't anticipate us doing anything on this particular case because it's a personnel case. It involves something outside of our county. But when we start talking about Vanderbilt having the authority that the police department has, I think it's important that we have some agreement with them just in case there is something major that comes up, and we want to be able to take part of it and also deal with accountability within that police department as well. Just and simply because OPA has that same authority. So that concludes my my ED report. And I did want to say one thing before we move into the PRRs. I handed you out the discipline grid, but also in that I attached 3 policy updates. Those policy updates that I attached were the result of our PRRs. So we had a PR sometime in January, and then we had another one, I think it was in April. And with those, there were 3 policy updates that came out of those 2 PRs. One was how they report traffic accidents, or a refresher. One was regarding the consent to search. They changed a slight line in there and also put a refresher. And then the last one was in regards to the daily reporting and how that would look going forward. So I think that with those policy changes, not only is it, I think that's a success when you have those changes being made to policy because of this process that we're doing. So that concludes what I have to say about that. Thank you. And I'll take any questions.
Any questions for Director Fitzgerald? Mr. Campbell-Gooch.
Sorry, I know that's really loud. So thank you for that. Thank you for that report. I wanted to go in reverse. I think Vanderbilt has what they call the core committee, which I know I had friends complain about VUPD to them. So I think they actually have a committee or a board type of function on campus, and that's called the core committee. And then also, I had a question about the body-worn camera footage. I know in the past you mentioned that the footage that we were all getting was redacted. Was this footage redacted in any type of way?
Yeah, so I talked to him about redactions, and what Chief Hagar told me was that we should not be getting things redacted. The only redactions that would take place are the redactions that were already included in the addendum, the things that are protected already by the state legislation or state legislators. And so that would be the only information that would be redacted.
Okay, and then on the part where there was a transition between us doing an official investigation with the TBI and doing the audit, does there need to be an official board action when it comes to making that transition between those two things? I was just curious. And I don't know who that question is for.
Okay. Attorney Yoon thinks that we should just make that change in the standard operating procedures. Now, unless a board member has something to say about it, I mean, I think it's open for discussion if you want to talk about like that process and how that would look. As a matter of fact, when we have our special call meeting, we will introduce to you an audit that we did on an OPA investigation. So you'll at least get an opportunity to see what that looks like. Yeah, if you want to have a discussion about it, we can, and why, but I think that would be a route to take to move us forward on those. Now, with that said, we still have to get the information from the District Attorney General's office in a timely fashion to be able to close our cases. So that responsibility still lies on the ability to get the records.
I think okay, yeah, I think that makes sense, and I'll be curious about what other board members think. But my last question, and this is just a simple yes or no, is the Force Review Board meetings open to the public?
No, those are not open to the public. I think I am actually the only civilian besides OPA that is in those meetings.
Thank you, Mr. Campbell-Gooch. Any other questions for Director Fitchard? If there are none, I wanted to put Mr. Abdullah on the spot here and have him introduce himself and tell us a little bit about himself before we move on.
My name is Hamid Abdullah. I'm the newest member of the Community Oversight Board. Before I got here, I was working with the Brothers Roundtable and working in the community, doing quite a few things. A lot of what we would do would be community cleanups. We would host events in the community such as Juneteenth, and basically history. We would teach history to community members. I was nominated by AMAC, which is the American Muslim Advisory Council, and I am currently working with Pencil, which basically worked with public schools and private businesses in matching or helping to. I'm sorry.
We've lost our feed.
I don't know.
So working with Pencil, where we would bring the public sector as well as public schools together and to help them achieve things that they need for their schools. So that's all I have. Thank you.
I'm trying to it's not doing anything. I don't know what to do. Back there. I broke it. Can you hear me? Yeah. Everyone can hear me okay? All right. Thank you, Mr. Abdullah, for introducing yourself. Welcome to the board, and thank you for your service here. Before we move on to the PRRs, I just wanted to give a reminder to the board about these reports. So these reports represent the totality of the investigation conducted, evidence collected, and conclusions reached by the staff. Our decision today should be limited to the evidence as presented within these reports. As a reminder, we are to be impartial in our review. We must be judicious and only consider the facts and evidence as presented here. Our rules state that we must presume that each report is correct as written. This presumption requires that all evidence was properly collected by our investigators and that the evidence was properly reviewed by the executive director. Then, based on a preponderance of the evidence, made appropriate recommendations. Our role is to review the report as written and determine whether the report is adequate and whether the disciplinary measures proposed are sufficient and consistent with civil service rules. So I'll hand it over to Director Fitchard.
All right.
Let me, as a reminder, that if you double tap that microphone button, or the button with the person, it'll mess up. So try not to double tap it.
Yeah, it's real finicky. All right, thank you. I'm going to cover the first case. It is complaint number 2020-006. I'll outline it by summarizing the complaint allegations, a few facts about the case, a little bit about the discussion and analysis, and then the conclusion. So this case 2020-006, the allegations of misconduct are allegation 1, improper search and seizure against Detective 1, allegation 2, improper search and seizure against Detective 2, allegation 3, improper search and seizure against Detective 3, allegation 4, improper search and seizure against Detective 4. And these are the allegations. On February 28, 2020, a Metro Nashville community oversight investigator received a complaint from the complainant alleging that misconduct against 4 officers, Detective 1, 2, 3, and 4, alleging they conducted a search of her residence after threatening her with eviction if she did not consent to the search. Specifically, the complainant states that after being away from her home for about a week, on February the 19th, 2020, at approximately 12 p.m., she heard loud banging at her door. The detectives explained they were responding to an anonymous call saying she was selling drugs. They asked if they could enter the home, which the complainant allowed because she said she had nothing to hide. Once inside the home, however, complainant states that the detectives told her she would be evicted if she didn't comply with their request to search the rest of her home. She informed the detectives that she did not receive public housing assistance and asked to speak with the property manager. The detectives responded by saying it was the property management's rule that she would be evicted if she did not cooperate. She stated, the detectives intimidated me to make me sign the search warrant. After the detectives informed her the property manager would evict her if she did not cooperate, complainant signed the form allowing detectives to search her residence. She was subsequently charged with 3 misdemeanor citations and the property seized. The violation is Mnpd Policy and Procedures 5.20.020, searches by consent. And just as a caveat, I want to add that this policy had a change in the way that it was written on 8/16/2021. But the policy states that that detectives may conduct a search of a person or property by obtaining prior consent. The consent must be voluntary given, and that voluntary consent must be shown to be unequivocal, specific, and intelligently given, uncontaminated by duress or coercion. The consent must be proven to be voluntarily given by the preponderance of the evidence and is never lightly inferred by the courts. The prior consent must be obtained from the person or persons with authority to give valid consent. Consent need not be in writing, and a refusal to give written consent may still permit a valid oral consent. I reviewed the investigative file, which included the misdemeanor citation, the complaint form, the signed consent form, the recorded interviews of all parties, which was the complainant, the detectives, and the property manager. So the findings of the fact is on February 19, 2020, 4 Mnpd detectives responded to an anonymous tip that the complainant was selling drugs out of her home. They conducted a knock and talk. There was an odor of marijuana emanating from the complainant's apartment. As a result of that odor, detectives notified the complainant that she would either consent to a search or they would obtain a search warrant. She granted oral authorization for the detectives to enter and search her home and later signed a consent search form. She was issued 3 citations. As a result, well, before that, they located a weapon, a small amount of marijuana, and a single Xanax pill. She was issued 3 citations. She said she did not sell drugs. She stated that she felt threatened by the detectives and signed a consent form under duress. There is no evidence within the record to support the complainant's allegations that she was told she would be evicted for failing to comply to search. The discussion, it is undisputed that Mnpd detectives searched the home as a result of an anonymous tip that drugs were being sold from the home. It's undisputed that when the detectives arrived on the scene, there was an odor of marijuana emanating from the complainant's apartment. The smell of narcotics in the complainant's apartment, along with the anonymous tip, would likely have been sufficient for the detectives to obtain a search warrant to enter the home. And there's no dispute that the complainant granted the detectives both oral and written authorization to enter and conduct the search. Mediation was not offered in this case based on the nature of the complaint. And my conclusion is that after careful review of all supporting documents, the MNC investigative summary, the recorded interviews of the complainant and the detectives, and based on the preponderance of the evidence, the allegations for improper search and seizure are not sustained for Detective 1, 2, 3, and 4. And that concludes my report.
Thank you, Director Fitchard. Any questions from the board members about Director Fitchard's report? Mr. Hayes.
It was the same question that I asked earlier, if there was any body camera footage, but my understanding is this was before the body cameras were implemented.
That's correct.
But that would have been very helpful.
Your microphone, Mr.
Okay.
Yeah.
Yeah, I was saying that body camera footage would have been very helpful, but you were saying that that was before, that was prior to body cameras being implemented.
Right. This happened last year in February.
Yeah.
Thank you, Mr. Hayes. Ms. McCree?
I just wanted to ask a clarifying question on the policy that was changed on August 16th. The policy was only updated to include that they can give consent via the body-worn camera footage. Is that correct?
Yeah, so the policy for consent search, in the old policy, there was a sort of like a note attached to the original searches for consent, how it was written. So the old one basically said that it was strongly recommended that they obtain a written consent. In the new policy that came out on August the 16th, and this is the same policy, 5.20.020, searches by consent. The only change in this policy was a language change, and it says instead of, as a side note, it is strongly recommended. What it says now is it is expected that officers will attempt to obtain written consent using the proper departmental form prior to conducting a consent search. And so I think that that's stronger language, and I think that the change came about after it was brought to their attention in another case that we had. So I do think that the new language is stronger than it was before, which kind of gave officers the opportunity to decide not to go that route.
Mr. Goddard?
Yes, following up on Ms. McCree's question, does the new policy require or recommend or reference any oral consent being on the video for the body-worn camera? Is that a requirement for that?
Well, in this new policy, what they created was they changed that language. They said they deleted the old one in its entirety and replaced it with the new following changes. And they give a whole training refresher on those, consents. And it does talk about documentation, which is use body-worn cameras or in-car cameras to document interactions, the consent request, the explanation of rights, and the consent process.
Needing to be on camera?
Excuse me?
All of that needing to be on the video to be valid?
Yes.
Oh, okay. Thank you.
Officers should, as with any activity,
Okay.
fully document their actions.
Mr. Kamalguch.
Yeah, I think mine's more of a comment about a pattern between this one and the last one we reviewed of someone being threatened with eviction if not consenting to search. And I think maybe that's a place where we can do what are national best practices to make sure people understand just do a public education on what their actual rights is when it comes to consenting to search. Mm-hmm. And then two, what is the official policies between Mnpd and landlords? Because, I mean, this is the second time someone has literally complained to us saying that they felt forced into allowing someone to search their property. So I think outside of the complaint and what we decide to do here, I think it just speaks to a bigger problem where we have people who literally feel like they don't have the option of saying no to someone, especially when being threatened with eviction when housing is the way it is right now in Nashville.
Yeah, and I'll say to that point that, number one, the last case that we had was MDHA property, and that was a reoccurring theme that was happening, I believe, where the people that we have had contact with or who have made allegations about these improper searches, they have mentioned that they were threatened with, eviction. The difference in those two is this case is a private landlord, right? And the landlord, when speaking to her, said that there is no such policy that she has. And she also wouldn't give the police department a whole lot of information because they also have protections. I think landlords without giving information without a warrant. So, but I do think you're correct in saying that it is something that we need to do as an educational outreach to let people know what their rights are, that especially those that live in public housing as well.
Yeah, and I was trying to find it in the report where it says the response from the person was, this isn't public housing. So, I mean, I think that also shows that, like, people that are renters from that are renting from private landlords also are like, yo, this ain't public housing, you can't run my stuff, which is also a misinformation right there. Mm-hmm. So I think it's just like an opportunity to both provide a lot of education and then also provide some guidance on the police shouldn't be saying that either if that's not true. So yeah, I wanted to hold that.
I agree with that. And then also, I think another point to that is you don't have to live in public housing to receive public rental assistance. Yeah. And so that they would still fall under like some type of federal guidelines through the Department of HUD that we also need to, I think, be cognizant of as well.
Thank you, Mr. Kamalguch. Any other questions for Director Fitchard? Mr. Holloway?
I have a statement. We got to look at it now. It's a new day and time in policing. Whereas one time you could get by with to the people saying that they get evicted if they didn't cooperate. So that doesn't fly anymore. That's the reason why we got cameras to record. And so the camera can verify the action that is taking place there. And if not, then the people have another way of pursuing a civil suit or whatever, But like I said, it's a new day and time, and so it should be taught in the academy that, we cannot bogart our way in people's houses and use scare tactics to get the job done.
Thank you, Mr. Holloway. If there are no other questions, Mr. Hayes.
I just wanted to bring out this part about an anonymous call And I think that probably is a tool that can be used for profiling. There could be cases where people just don't like the person, and then it's an anonymous call. And whoever's on the receiving end of that is at the mercy of that. So I don't know if there's any data that's kept. Do they ever go back to the person that made the anonymous call to say that wasn't true, or in cases? But I just wanted to bring out that's problematic also to me, an anonymous call.
Well, we did try to verify that information in the investigation, and in the summary, our investigators were able to determine, based on what the complainant said, that there was this issue that she had with a person that she knew.
And I'm not arguing about this case.
Right.
I'm saying there are other cases. That's typically, we received an anonymous call. So, thank you.
Mr. Campbell-Gooch.
Okay. I also wanted to mention, and this is just a curiosity, and maybe a place that we need to go to, maybe not at this time, but later. But I'm curious on how, I know it has to be difficult to prove that someone felt intimidated, right? I know that's probably like unmeasurable, but I still think it's, I'm still just trying to think through what's the process of this board and what's the responsibility when it comes to someone feeling intimidated, and what are some action steps we can do to help protect that person. Now, I know that there are limits, right? I know that there's limits because I don't know how we investigate that, but I'm just curious on how we hold if someone literally feels like they just don't have the ability to say yes because no, because there's a power dynamic there. Which I feel like, even with the next complaint, not getting too far ahead, we're dealing with someone again who feels like they don't have an opportunity to say no here. And so, I wanted to bring it up to not only the staff, but to the board on like, how do we work on situations where community members literally feel intimidated to give up their rights? And I just wanted to mention and hold that because I think that's a place where this board can be instrumental in supporting those folks.
Thank you, Mr. Campbell-Gooch. Mr. Abdullah, do you have? Yeah.
So one of the things I'm thinking about is patterns, and is it a way for us to go back and take a look at, say, particular officers when they have these types of complaints, if there's a pattern of them doing that, and if so, to me that would be the thing that shows what they're trying to put out. So like he's saying, there's no way to say how a person felt, but if this person has a pattern of doing that, then they know the result that they're looking for.
I do think that comes down to educating our community on knowing their rights, especially as it pertains to searches of their homes and their cars and all of that. And so I think it can be done through a community endeavor, but overall, I think that you're right. I mean, most people will, there is a power dynamic there, and it may be something that's difficult for us to do in just at one time, but it's something that should be done on just an ongoing basis, to letting people know what their actual constitutional rights are as it comes to searches of their property.
Judge Brown.
I agree that certainly education is appropriate, and that should be part of our outreach. Of course, in this case, to comment on Mr. Hayes' comment, in this case, you did have an anonymous complaint, but the officers also then had probable cause that probably would have issued a warrant had it been produced, that they smelled marijuana when they got there. So without corroboration of an anonymous complaint, then the officers probably would not have even asked to search. But their testimony, as I understand it, was when they got there, they smelled marijuana, and that takes it over the probable cause issue. But still, the individual could have refused, but then the officers would have, according to them, they told her, they would get a search warrant. And with the evidence that the investigator produced, it looked like they would have had probable cause. But I agree with the necessity of education for the public. But I think the report is adopted, as presented by the director, is accurate, and I move its adoption.
Thank you. So we have 4 choices here to accept as submitted, accept but with edits, reject and request a revision that reaches a different conclusion, and return for further investigation or analysis. So you're moving to accept as submitted. Is that correct?
I'm having a double.
You're moving to,
4 pieces.
yeah. You're moving to accept as submitted.
I'm moving that we adopt the report.
Okay. Is there a second to that?
I will second, but just so we have a motion on the floor, not to
Yeah.
cut off questions.
Okay.
And
Mr. Campbell-Gooch.
Mine is more of a comment. If there's a motion on the floor, I could just hold.
We can keep discussing with the motion.
Okay, so I just wanted to mention something that Board Member Abdullah just kind of glanced over. I know that there's been reports on police misconduct that literally talks about how police misconducts happen in networks. In other words, like police that are causing extreme harm usually hang out with other police that are causing extreme harm. And so I think that might be also another place where we can maybe audit and talk about and track are police that are behaving in this manner, using intimidation in this type of way. Are they in networks? Are there commonalities? Are they pooling in certain precincts so that we can actually get to the point where these things are solved? But I just wanted to mention that might be a place that we could possibly go.
Mr. Wynn.
This is for Director Pitcher. You know, this is anonymous calls are what Crime Stoppers is all about. That's how they solve murders and all other kind of crimes. So we don't want to throw the baby out with the bathwater, but it'd be interesting to find out how many narcotics calls they get, anonymous narcotics calls, because at one time Crime Stoppers, even though they didn't take the name, the person wouldn't give them the name, they do record that, and then it goes out to the field for enforcement. So there's a record there. So if this individual officer is fabricating an anonymous call or doing something dishonest, then we should know about it, and the department should as well. So yeah, I wanted to bring it up. We don't want to, not get anonymous calls from the public. That's how a lot of our crimes are solved, that would otherwise wouldn't be.
So if I hear you correctly, what you're saying is when it's an anonymous tip, then it would be going through Crime Stoppers. It wouldn't be going through the 911 database or ECC.
Now, that I don't know. I mean,
Right.
At one time, this was the way it worked, or they had the Vice Division had an anonymous narcotics number that you could call and complain on a neighbor who was selling drugs or there was activity in the neighborhood. And I don't know if that exists today, but at one time it did. So there's a record of that call that comes in.
Gotcha.
So if there's no record of a call coming in as an anonymous call, and the officer is saying to the resident, somebody called and said they smelled marijuana here, then there you've got an integrity problem.
Right.
So
And I will say this, that when we do try to make certain that when we get the officers' information, that we check it against other information that we have to see if there is a pattern and a practice. And we are now really beginning to keep track of that even more since we now are getting more information in regards to officers who have certain types of misconduct or filling out certain forms. And so we are keeping some track of that now.
Dr. Hildreth.
Thank you. Mindful that there is a motion on the floor, I just wanted to make a comment to pull together these 3 threads from Member Abdullah, Campbell-Gooch, and also Wynn. It sounds like we, the board, are making a recommendation to Dr. Wheeler that there are some research questions that are being framed up about looking for patterns of individual officers as we are looking for all of this work, at looking to see whether or not there are networks. Are we seeing that certain officers seem to be in tandem with each other, and then cross-referencing other data sources where information, particularly around anonymous tips, are being made. So I just wanted to collect those in a global comment, asking, not a motion, but just asking our very capable staff to unleash those formidable powers on thinking this through and designing ways in which we might look at this going forward. Thank you.
Thank you, Dr. Hildreth. Any more discussion on this PRR? Okay, the motion is to accept as submitted. All in favor, say aye.
Aye.
Any opposed? Okay, we can move on to the next one.
All right, the next one is case number 2020-010. The allegations of misconduct are allegation 1, improper search and seizure, allegation 2, vandalism, allegation 3, lack of professionalism. I'll read the summary of complaint allegations, I'll read the policy violation, and some findings of facts, and the discussion, and then the conclusion and additional findings. A complaint was filed on behalf of complainant 2 by complainant 1 with the Metro Nashville Community Oversight on March 31st, 2020. The complaint alleges that multiple officers, including Detective 1, Detective 2, Detective 3, conducted a search of his residence without his consent, vandalized his motor vehicle, and lacked professionalism. Specifically, complainant 1 stated that her son, complainant 2, was arrested on March 27th at his home in Hendersonville, Tennessee by Metro Nashville Police and the Hendersonville Police for outstanding warrants from Davidson County. Complainant 1 alleges that complainant 2's home was searched and property seized without consent. Complainant 1 asserts that complainant 2's keys were taken, 2 vehicle tires were flattened, and his truck was seized. The complainant stated that during her encounter with Mnpd detectives, she felt they were giving her the runaround. The policy violation is Metropolitan Police Department Manual Section 4.20.040K, the obstruction of rights. Any employee who knowingly deprive any person of any right to which they are entitled by law or the rules and regulations of the Metro government. The next policy violation is Section 4.20.050W2, other property. Employees shall exercise all due precautions to prevent theft, loss, or damage to property recovered by or entrusted to them in the course of official business. In the event that the theft, loss, or damage is due to a willful or negligent act of or omission by the employee, appropriate restitution shall be made. Mnpd Manual 5.20.020A, searches by consent. Officers may conduct a search of a person or property by obtaining prior consent. The consent must be voluntarily given, and the voluntary consent must be shown to be unequivocal, specific, and intelligently given, uncontaminated by duress or coercion. The consent must be proven to be voluntarily given by a preponderance of the evidence and is never lightly inferred by the courts. The prior consent must be obtained from the person or persons with authority to give a valid consent. The consent need not be in writing, and a refusal to give written consent may still permit a valid oral consent. And lastly, Mnpd Manual 4.20.040, personal behavior courtesy. Employees shall be courteous, civil, and respectful to all persons and shall make every effort to meet the needs of citizens requesting assistance. I received the investigative file. It contained the complaint form, investigative summary, photographs, the vehicle hold report, a tow slip, a tow ticket, the search warrant, the affidavit, the 18th Judicial District's inventory report, the Mnpd Police policy manuals, recorded interviews of the complainants, recorded interviews of the detectives, and the disciplinary files for the detectives. The findings of fact. On or about March the 27th, the complainant's son, complainant 2, was arrested in his home in Hendersonville as a result of an outstanding warrant in Davidson County. There were officers from both Hendersonville, which is Sumner County, and Mnpd present at the scene. Mnpd Detective 1 was the only officer at the scene and entered the residence after it had been searched by the 18th Judicial Task Force in Sumner County. Officers from the 18th Judicial Task Force advised him that they had obtained oral consent to conduct a search. Mnpd officers Detective 2 and 3 were not present at the arrest or when the search was conducted. Complainant provided conflicting testimony as to whether he consented to the search of his home. At the time of arrest, the officers from the 18th Judicial Task Force deflated the tires of the complainant's truck, to prevent any escape attempts. However, the officers reinflated his tires following the arrest. Officers recovered narcotics and a weapon from complainant 2's home. However, charges were not filed. Following complainant 2's release on bond, complainant 1 was unable to retrieve her son's truck or cell phone, which were being held for an investigation. Complainant 1 reached out to North Precinct multiple times to get information about complainant 2's truck and was told it was being held for an investigation. Complainant 2's truck was seized on March the 27th and released to him 18 days later on April the 16th, 2020 at no charge. And there is no evidence that supports an allegation that a member of Mnpd vandalized the complainant's truck by letting the air out the tires. The discussion, so it's uncontested that this incident occurred in Hendersonville and involved officers from Hendersonville and Mnpd. It's also undisputed that Detective 2 and 3 were not present at the complainant's arrest or the subsequent search of his home. Detective 1 was the only officer who was present at the scene. The evidence within the record shows that Detective 1 was not involved with the arrest and entered the home after the search had been completed. Detective 1 stated he was informed by Hendersonville officers that consent was obtained. Based on this information, he entered into complainant 2's residence. There is an issue related to whether complainant 2 consented to search of his residence. During the investigation, complainant 2 provided inconsistent testimony of the search incident of his home. Additionally, because of the alleged consent was either obtained or not obtained by Hendersonville officers, it is not relevant to the allegations facing Detective 1. If there was a failure to obtain consent, that failure lies with the officers in Hendersonville's 18th Judicial Task Force who are outside the jurisdiction of this agency. The record reflects that complainant 2's tires were deflated by the 18th Judicial Task Force in an effort to prevent any attempted escape by complainant 2. The record demonstrates that this decision was made solely by the officers in Hendersonville and not by Detective 1. Finally, there's an allegation by complainant 1 that Mnpd detectives gave her the runaround while attempting to locate her son's possessions. The record demonstrates that complainant 1 was notified that there were holds placed on complainant 2's vehicle because there was a pending investigation. There is nothing to support an allegation that an officer was discourteous or gave her the runaround when answering questions related to complainant 2's truck or personal items. Instead, the record reflects that complainant 1 was instructed that the items were on hold as an investigation was being conducted. Moreover, the record shows that the vehicle was impounded on March the 27th at the time of the complainant 2's arrest, and that he attempted to retrieve that vehicle on March the 28th. But his vehicle was subsequently released 18 days later on April the 16th. The storage fees for that vehicle were waived. Mediation was not offered in this case based on the nature of the complaint. And my conclusion is this. Executive Director concludes that after careful review of all supporting documents, the investigative summary and recorded interviews of the complainants and detectives, and based on the preponderance of the evidence, the allegations for improper search and seizure, vandalism, and lack of professionalism are not sustained for Detective 1, 2, and 3. However, there are some additional findings, and I found that Detective 3 violated Mnpd's policy regarding vehicle holds, which is Mnpd Manual 6.20.080. And what it says, and I'm going to summarize it because it's a long policy, but vehicles may be detained or held for up to 72 hours and will not be released without authorization from either one, the officer causing the hold to be placed on the vehicle, or two, the officer in charge of the investigative element to which the hold is directed. In this case, the officer admitted that he did not place a hold on the vehicle, even though he knew that the vehicle was involved in an investigation. My recommended action is the executive director found that Detective 3 is in violation of Mnpd Manual 6.20.080. Detective 3 should have requested and completed an Mnpd vehicle extension form, but did not. After review of Detective 3's disciplinary file, no other similar violations appear. And according to their grid, my decision for discipline is a written reprimand. And that concludes that report.
Thank you, Director Fitchard. Any questions for Director Fitchard on this proposed resolution report? Mr. Campbell-Gooch.
2 questions. First, clarifying question. Was complainant 2 living with complainant 1?
I don't have that information.
Okay, and then the second piece is what, and I'm just curious on this, what does the follow-up with the family looks like? Because the reason why I'm holding and asking that is because if MNPD was supposed to keep a car or hold for 72, and also correct me if I'm wrong here, if it was supposed to only have it for 72 hours, but they ended up holding it for 18 days, that could have like tremendous effects, especially on employment. So I'm just asking and holding space around like what has communications with the staff and the family been like, and just like what has the feel been for those folks?
So if I'm understanding you right, like the vehicle belonged to the son, and the mother, she didn't make any acknowledgement that this was causing them any type of issue, as far as I know.
Okay, I was just curious about that because I know that we're talking about the complaints and the actions of the officers, but I just wanted to hold space for the people that were involved in this situation. So that's why I just wanted followed up with that question.
Understood.
Mr. Holloway, did you have something?
Yes, I think the decision was made simply due to the fact that you look at it as disciplinary file and no disciplinary action had been taken before on this officer. Is that correct?
Yeah, not for this type of allegation.
Okay. I don't agree with it, and not saying that you're wrong. His vehicle was being held, and then they waived the fee, but what could he do if he had had his vehicle? Could he been employed doing something, you know, or did he had to take a cab or a bus for employment, you know? And this, to me, put him in a situation where he didn't have transportation, you know, even though they didn't charge him anything, but he had to have some way of getting around, or whether he had to use his mom's vehicle or some other relative or what have you, you know. But yet and still, this is, like, to me, just like a slap on the hand. 1 or 2 days wouldn't hurt.
So that's why I included the discipline and corrective action grid for everyone to have, so that they can determine when I'm making the decision what the discipline actually looks like. And so if you look on there, what his violation was if you go back, it's a category F. And so a category F, let's see where that one is, hold on. Vehicle hold 6.20.080. That was that was what he would have, yeah, that would be the violation. And that violation would have been a category F.
So question is this his first or second offense?
He was never been corrected for anything like this before, so that would have been a first offense.
Okay, I'm just looking at the grid here, and for second offenses, it's lining up with, or the recommended punishment is lining up with the second offense. And I'm not disagreeing with the report, but according to the grid.
Oh, I see it, yeah.
Yes. Just wanted to take note of that for public record.
Just 1 second, please. Okay. I think on this particular case, this will have to be modified because when I went through this, I don't actually, now that I'm looking at it again, I don't actually see, and I think that this is something that we have had to discuss in regards to additional findings, because we have the allegations of misconduct, and those allegations of misconduct are categorized. But when we have additional findings, right, which usually deal with a policy violation, we haven't really articulated them well on this report. And so my suggestion is that you reject this and let us take it back and modify it and then present it to you again or make the corrections. Because it's not, we don't have the additional findings attached to a particular, we have the information in there, but the category is not included in here. And so because of that, I would say that it needs to be modified.
Mr. Witzel and then Dr. Hildreth.
Yeah, I was interested in knowing, from what I understand, there was conflicting, I guess the complainant too gave conflicting stories about whether or not consent was given. And I'm interested in knowing if anyone knows that if the Hendersonville police tells Mnpd that they have gotten consent, but the person there states that they haven't, do we know what the protocol is for that?
I didn't understand your question.
I'm sorry. Just there were conflicting stories about whether or not that complainant actually gave consent to search, and in situations like that, if the Hendersonville police tell Mnpd that they've gotten consent, but the complainant says to them that when he arrives, or when the police officer arrives, that there wasn't consent, do we know what the protocol is when the police are saying one thing and then the complainant is saying something different?
Out of jurisdiction? You mean in another county? Or if I'm understanding, did you get the question right?
I'm sorry, I was looking at
Oh, okay, sorry.
Yeah, I'm sorry if I'm not being clear. I get
what you're saying, like if there's consent, like, between the two different agencies, you mean? I mean, I think that this is a peculiar case, number one. I mean, because we wouldn't be involved in it in any other way, except for there was this investigation pending. Because if this happened in Hendersonville on its own, we wouldn't be involved at all. The only reason why Mnpd was involved was because they called them out there because they had a hold on the vehicle in Davidson County. And I don't want to get into all of those details because the case is a very peculiar case. But at the same time, I do get what you're saying. And if, we could have called the Hendersonville Police Department. I mean, they may or may not have agreed to, talk to us. I don't think that was something that we did. We did talk to the complainant. I listened to the recordings of the complainant. We got all the documentation that we could get from Hendersonville. And the complainant, too, made multiple different statements. And I think that is where we said that there was a little bit of inconsistency.
Mm-hmm. Thank you.
Go ahead, Danielle.
Okay, if I can respond to the previous question, actually. When we were looking through the report, we pulled up the manual, and the rule violation, although it was 6.020 with the vehicle slip form, what that is a violation of 4.20040, which is adherence to rules and policies. So failure to do 6.020 was actually a violation of policy 4.20.04, which is included in the packet. That's a category D offense. And then as a first violation, they would actually recommend a 1 to 4 day suspension. So Director Fitchard's recommendation to you is to go below that to what would be considered a category E violation as a first offense, which can give either a 2 day suspension or written reprimand. If you were to be consistent with the first offense category D, it would be between 1 and 4 day suspension.
And my recommendation was based on not having that policy at the time, or not reviewing it.
Okay.
Thank you. So my original question was, Director Fitchard, I thought I heard you state first when you were indicating the prior history of this officer that there were no priors in this category. So I was asking a clarifying question about how we are to interpret the grid and which offenses are included or not included in the countdown of first, second, and third. And then now that we have this information provided by Mr. Yoon, I'm wondering, is your recommendation still to us to reject this so you can revise and come back with a recommendation that fits with the grid as you now understand this to be a category D?
I would like that. Because it says in here they have, there are no other similar violations that appear, but I think that I need to review that policy just to be sure. I don't want to just make some type of random decision without really seeing that particular policy myself and laying eyes on it, and then going back and reviewing this officer's disciplinary file just to make certain that I am presenting to you the most accurate information.
Director Fisher, I think you're doing a fine job. And
I appreciate that. Thank you.
But we also have to keep in mind that the rules are not for everybody, even though it's supposed to be, but it depends on how they enforce them with the Mnpd. How well do I know? And it makes a difference who you are. But thanks goodness to the COB that we can help correct that matter.
Judge Brown.
I guess one of the problems I'm having is with the masks on, I'm having a devil of a time hearing. I've got my hearing aids turned up, but maybe if we could take the mask down when we're speaking, I'm missing a lot of what's being said with all the plastic and everything. I would comment, I took up Director Pritchard's invitation to come down to the office, and so Monday, I believe I went down to the office, got a nice tour of it, and spoke to her and to our legal advisor, and I reviewed this particular file, and I understand the technical reason why I'd like to redirect it, but in this particular case, it does appear the detective made an error in not filing the extension, but there were other circumstances as why the vehicle was being held for another investigation, and there was a bullet hole in the mirror, and it appears that they did not charge any storage charges or anything else, so there was no storage charge. One of the things that sometimes on these vehicles being held is you get a very large storage charge, but they did release the vehicle when they completed their investigation in the other case. And so you do have a technical violation of not notifying it, which I understand the officer admitted that he didn't file it, but when it comes back, it appeared to me that I'd be interested to see what Director Pritchard recommends, but having looked at the file myself, I thought the reprimand would be an appropriate punishment, particularly when we're going back for something that happened 18 months ago. I just have a little problem sometimes with suspensions and stuff for something that occurred that far back. And it's going to be even longer by the time we finally get it done.
Thank you, Judge Brown. So we have options here. We can accept but with edits, or reject and request a revision that reaches a different conclusion. Dr. Hildreth?
No, please.
Oh. Oh, so there's 4 options. Accept as submitted, accept but with edits, reject and request a revision that reaches a different conclusion, or return for further investigation and or analysis.
Thank you. Move option number 3.
So
I second that.
The motion is to reject and request a revision that reaches a different conclusion. Any discussion on the motion? If not, all in favor, say aye.
Aye.
Any opposed? So we will revisit that then at the next meeting. Okay. Thank you, Director Fitchard, for those 2 reports. Dr. Valier.
All right, thank you. Good afternoon. So there's 2 items for discussion related to research and policy. The first one is related to the discussion last month. We extensively discussed recommendations related to the hiring procedures report, as well as the use of force recommendations that have been made by the COB and the Policing Policy Commission. We invited Mnpd representatives to come to answer questions from the board, and the police department said that the board can ask questions of Commander Lara, and he would be able to find answers to those questions if the board has them related to the hiring procedures and use of force. So if there are questions from the board specifically on those, we can discuss those.
Any questions there? Dr. Hildreth, I see your name tag, but okay.
Thank you. I have a question about the question. My recollection was when the recommendations were presented, there were a couple using the stoplight colors. Of green means the department agreed. Yellow meaning that there were maybe middling concerns, and red meaning that there was opposition to this board's finding. That I thought there was a question at the time, and the representative was not able to because it was a specialized thing, and I thought that we made this suggestion as a courtesy to the department so that it could give its best information in real time. So that was intended to both honor, respect, and help our standing representative, but also to ensure that this board and the community we represent and who is watching and listening to us could get the real information in real time so it doesn't drag out. So actually now where we are is, it is dragging out because perhaps I only speak for myself. I don't remember with clarity what the specific nuance was and what I was interested in, but I thought that our suggestion of asking the department to come prepared to talk about why we were in the yellow or the red zone meant that we could have a full and illuminating conversation in real time. Perhaps I'm a little distressed because this is beginning to feel like slipping back into old habits. And that concerns me. I have been one of the first to commend the department, along with our staff, for moving past past difficulties and what seemed like obfuscations. I need to register my strong concern, considering the fact that I believe I'm the one who made the motion. So, no, I have no questions at this time. But should we have questions in the future, I would like for the department to be on notice that if we know that there are yellow and red zone questions facing this board, I'm going to expect a full, competent answer in real time, even if it means we move to delay this meeting so that persons can be brought in or talk to Captain Laura or whatever happens. Because what we're not going to do is go backwards, not on behalf of this community. Thank you.
Thank you, Dr. Hildreth. Mr. Campbell-Gooch.
And with that being said, I'm curious, both from board members and legal, what are our options when we do have questions that are being nuanced, but then also when we're getting different information from different sources and we know that we need someone in either the command staff or someone who is privy to different conversations to actually come here and answer questions that both we are curious about and the community is curious about too. And so I'm curious both to our legal advisor and board members what our options are when these things begin to happen.
Mr. Yoon, I don't know if you have an answer for that. Microphone.
I don't have an answer off the top of my head that I can communicate right now with any confidence. I would like to think about that and maybe get back to the board either later in the meeting or at another time.
So there, are you, again?
I was just going to say that getting clear information is the only way that we'll be able to hold folks accountable. And so it is disturbing that we are also getting information from several different sources that say different things, just straight up. If we talk about license plate readers, we're getting different information about how they're getting paid for, what Mnpd is currently doing with borrowing license plate readers from other areas. And we are put together as a board to be able to answer these questions. And I don't know if anybody else here, but when I leave this, I'm getting serious questions from community members about things that they are curious about. So that is why I'm just asking straight up, what are our options when it comes to these things and being able to literally provide our folks answers to things that they are not privy to, and in the past, it's literally been a blue veil hiding these decisions behind closed doors that I think Officer Holloway often talks about. So that's where I'm curious about what are our legal standings as a board and what are our options to execute when it literally comes to the point of lack of transparency and lack of actual cooperation.
Mr. Hayes.
I just wanted to say, I'm also concerned that no one chose to show up to actually talk to the things that we were asking about. It just says to me that it's just a disregard for accountability. That when I look that we have a government board and we have a government Mnpd, that's a part of the city. But when you get a department that requests someone to come and they just, well, no, we chose not to send anyone. It's disturbing. It's disturbing and very disappointing, but not surprised, but disappointing.
Thank you, Mr. Hayes. If there are no more questions or comments, Mr. Campbell-Gooch. Commander Lara, please.
Thank you. Good evening. So I understand that there's some concerns about who was going to come up and speak. Initially, we were going to have some personnel from some of the specific divisions, specific background recruiting, and those who can speak about use of force. But understanding that there are many different people that would have to be here, just because there's so many different areas that are covered, especially in the policies, as well as background recruiting, our training. After speaking with executive staff, I have some answers. I think one of the big things we wanted to do is see if there's any specific questions that are needed to be answered, and then that way I can get you good, educated answers, something that we can go back and really find the right thorough answer for. But I have some answers for some of the questions that were brought up last month. I know several had some concerns, and so I have some of those, as well as some clarification on some of the policies and some of the recommendations and the responses that we had. So again, if there's anything specific that you want me to address, I'm more willing to address and be able to maybe expound a little bit on some of the questions you have and some of the concerns you had. But if there's anything that I cannot answer, I can go back. If there's something specific that the executive staff can come up or can answer for you, I can take it back to them, and so we can get you a really good answer of what your concerns are.
Judge Brown, did you have something? Okay. Mr. Goddard and then Ms. McCree.
Yes. First of all, Officer Lara, I greatly appreciate your approach and tone and everything and information you bring dealing with this board. Nothing I'm getting ready to say is personal to you. I have the highest respect for what you're trying to do for us.
Thank you.
What has been requested is the opportunity to have a discussion, which means follow-up questions and answers and so forth, with somebody high enough in the department to be able to answer those questions. And what the department is bringing to us through you, this is not your choice, is not that. If that is acceptable, that I believe needs to happen. If it's not, I think we need to have a discussion at higher levels of why that's not a proper way to proceed, given what's been said.
Sure. Thanks, sir. And if I could respond to that. I'm a commander in the department, and so you're probably not going to get anybody over a commander position other than maybe the deputy chief that would come here. So I think the biggest thing would not be the rank, but I think who has the knowledge to be able to answer some of these questions. After reviewing the questions and concerns and reviewing last month's questions, I went to the different parts of the division, different parts of the department, and different divisions and trying to find answers to those questions. So that when I came, you didn't have, some of those questions were answered. I have a few that I remember. Mr. Hayes had a question, Mr. Gooch, and Mr. Gwynn, as well as Ms. McCree. Ms. McCree, so we had some of those questions answered. Again, because there's so much here, it's going to be hard to give an overview of everything, but we do have some policies. I have answers for some of the policy questions you have. I may be able to expound a little bit, but again, unless you have very specific questions, I can give you what I have, and if not, I can go back to the executive staff and see what I can get for you for anything specific that I can't answer here.
I appreciate that. And Commander, I'm sorry for trying to demote you to all.
No, not at all.
Perhaps what I'm asking is that whoever wrote these responses, made the decisions and wrote these responses, come and talk to us. I'm not sure who I'm asking for, but that's more what I'm getting at. Somebody said, this is our response, and some of those are yellow and some of those are red. And that person, or people, it shouldn't be too many, I believe would be in a decent position to have the dialogue that's being requested. Thank you.
Yes, sir. Thank you.
Ms. McCree, Dr. Hildreth, and then Mr. Holloway.
Thank you. I think I would just like to second his sentiments in that I appreciate your efforts in going to get the information from different members of your organization who would have those answers, but the request is to have them here in person so we don't have to wait a month or 2 months to have those answers, and that we can get those responses in real time. I speak for myself, but I'm sure other board members would not mind readjusting some things to make sure that we could have appropriate staff members here in person to meet with us. And so that's all I have.
And again, to respond to Ms. Cree, I appreciate that. One of the things to think about is when we talk about some of the things that we have responded to, there's more than one person. And just for an example, if we talk about de-escalation, you're going to talk about those who write the policies, which are in the STD. You're talking about maybe legal advisors that have a say in this. Then you've got the training academy and their staff who actually puts out training for these specific de-escalation tactics or techniques, I should say. So it's one of those where there's a lot of different variables, a lot of different people that would have to be here because there's so many different areas that need to be addressed, and one person may not be able to address all of it. And so what we try to do is give the best whole answer, and then if there's anything specific that you have outside of that, then we can get you those specific answers. But again, some of the questions that you'll have or some of the recommendations that were made and some of the responses we have, they're the full answer. Now, that full answer may have come from a bunch of different parts of the department that came together and said, hey, we need to think of this, we need to think of that, and then a full answer was given, and that is the response that you received. But again, if there's anything specific from the response that you need answered, then I can go and get that information for you. And I may be able to answer some of those things even now just by looking at the recommendation, maybe explain some of what the response we gave for the recommendations are. So it just all depends. And again, having everybody, for you to get a clear answer, you have a lot of people that would have to be here because a lot of people were involved in putting these responses together, if that makes sense.
Dr. Hildreth.
Thank you. And again, Commander Lara, I really appreciate this dialogue.
Yes, ma'am.
But I'm really talking about the process. When in the response of Mnpd, something sparks yellow and something sparks red. And I think the reason why this is so critical is because we found a lot of agreement. The majority was green in both of those instances we talked about. So there was immediate question wondering, well, what exactly in this caused the department to respond yellow or to respond red? And my memory is hazy and I did not review the tape. But my sense in the moment when we were struggling to continue to build good process together was that if we knew as close to the source as possible what the yellow tick or the red tick really looked like, we could have gone back and forth. And then if there was something deeper indicating beyond the one person you brought along with you, then that would only be a 1 month out. But we're sitting here and we're 1 month out from the original discussion. And if we ask you a question now and you have to take it back, we're going to receive that question 2 months back. So this was really intended as a process to bring the best information forward immediately. It was not intended as an inquisition. We don't want all of the departments that have a piece of that, but we both work in organizations, and we know that something will pop up. I'm in higher education. And there'll be something that pop up, and the faculty get really upset about it, but sometimes something else, and it's the housing director. And I'm not really close up on the front line with either of those, but if I know that the general yellow flare was in housing, I know who to bring. That's what we were asking, and maybe we misunderstood. But what I heard Dr. Valier first communicate is that there was not a perceived need on the part of the department to engage, as my colleague, Board Member Goddard said, that rich, thick conversation the first time. You have, the department has the suggested recommendations in advance as to the board members. So that's plenty of time to walk up and down the hall and get the consensus of the 20 folk and bring with you the one person who might speak to that thing that they're a little closer to than you are, than I am, because we sit high. That's what we're talking about. And that's the reasonableness that I strongly request go back and rethink the response, because the response, and I'm watching heads nod in the community behind you, I'm feeling it to my flanks here. That response is not acceptable in the spirit of where we're trying to get together. Thank you.
But again, if I could respond, would you give me the opportunity to answer any of those questions? Because again, understanding that I was here last month and I heard a lot of the concerns that y'all had, and I went back and spoke to those who have answers. I just request an opportunity to be able to see if I can answer those questions, because I may actually have the answers that you need. And again, did a little bit of homework myself, with the assistance of many in the department that helped me, and the executive staff as well, that helped me kind of put together, or helped me to understand why they responded the way they responded. And so I think having the opportunity to be able to answer those questions, you maybe get more than you realize. I'm not the one who wrote it, but I think I have enough understanding now from speaking to those who did put it together that I could give you a good educated answer on some of these. And there may be things that I don't understand that I can bring back, but I think that at the very least understand that I've got some knowledge on this, and they try to get me prepared to be able to understand what exactly was the response was and why they responded that way. I'm hoping that, I can answer some of those questions that you all still have concerns about. And that's the only thing I request, is that opportunity to let you know that they didn't just forget about it. They didn't say, hey, let's not do anything. They just knew that I'm here, and they prepared me with the answers and information that I needed, and I want to be able to get that to you, to the board, if there's an opportunity for that.
Let me go around. There's a lot of people who have questions right now. Mr. Holloway?
Yes, I don't know if you had a class just graduated or getting ready to graduate, but I'd like to know the makeup of the class. And from my understanding, I believe you got a lot of transfer class. You're getting ready to start, or have already started. And I'd like to know the makeup of that. And I don't like the word minority. You get lost in the shuffle. And one of the biggest complaints I've been getting is a lot of officers are not people friendly. I've been in situation here recently that I spoke and got no response. And one day I was in my retired uniform, spoke, waved, no response. So I don't know if the badge too heavy for them or not, but maybe the training in the academy can help educate them to be people friendly, because you don't never know when you might need the community for your help.
Thank you, sir. And I will go back and get that information for you, all the specifics on the demographics and everything else on the academy and anything else you ask, and I'll send it to Director Fisher, if that's okay. Thank you.
Mr. Nguyen, and then Mr. Hayes.
Yeah, thank you, Commander Laura. Is this your assignment? The executive staff assign you to us?
Yes, sir. I'm the COB liaison, so I work directly with Director Fisher and Assistant Director Clossy, and I am the go-to, kind of the in-between the department and the board.
Okay, so when we give you questions, then you go up and down the hallways of headquarters and try to find the answers from the particular experts or the people who are responsible or accountable. Is that right?
That's correct.
So would it be difficult for you as that liaison to produce sort of a chart of accountability for us to see which bureau commander is responsible for what issue that we're looking at, from firearms to hiring to discipline to investigations? Could you do that for us? So if we had a question where we wanted that commander, that bureau chief, or Chief Drake to sit in that chair, we could look at that chart and determine who that might be?
Yeah, I can get you a chart of the makeup of the department and all the heads. That's not a problem at all.
I know that's one thing. We can do that online. But what their responsibilities are in the fields that we want to know about force issues and about personnel issues. So just anyone looking at it might not be able to determine which one of those people in authority have those responsibilities.
Sure. And what I can do is I can go back and talk to the executive staff and address that question with them so that we can get you something, whatever the executive staff decides how they want to address that, and get you whatever information you need on that.
No, I think it would be important for us. I mean, I agree with the other board members that, you know, you're a good representative and we trust you. But, you know, I think my feeling is the board requires the direct people accountable and responsible for these kinds of issues and decisions should be in that chair. When we meet, they should be here as well.
Absolutely. I think one of the things to look into as well would be just the MOU, and I'm not, you know, to see what the arrangement was for these type of things, getting answers. So I think that's one of the things that we look at, and how we govern, how we interact as a department and the board. But apart from that, you know, the Chief Drake has been clear that, you know, now as opposed to in the past, you have somebody that you can go to for, you know, questions and any type of issues, of just to kind of facilitate things. Again, things like this, I have enough knowledge, I believe, and have been given enough information to be able to answer specific things. Now, again, there's always going to be things that I may not be able to cover because they're so specific, but those very specific questions I can always take back to the board, to the executive staff, or find out who has those answers. But to have everybody coming here, I think would be very difficult, and because there's so many people, again, that are involved in some of these decisions. But again, you know, I will bring your concerns back to the executive staff and see how they want to address that.
Well, and we wouldn't want, you know, to have a constant flow of, you know, commanders coming in and out of the board meeting. But I think what Dr. Hiller's talking about, when you get into those hot zones, then I think we expect the people most responsible for what we're asking about to be here to answer these questions. So thank you.
Yes, sir.
Whatever you can do to help us see who is responsible for these different areas, I would appreciate it. I'm not sure what the rest of the board would.
And again, I'll work with Director Fitchard, Assistant Director Clossy, and get what information through them.
Thank you.
Thank you, sir.
Mr. Hayes.
And I do want to concur that what everyone else has said, you've done a very good job working with the board, Commander Laura. But I want to look at things from really more like what I say is the 30,000-foot level. I feel that this board is being disrespected. And the reason why I feel this board is being disrespected is because I have gone to Citizens Police Academy training, and there's one going on now. And I know so many different ranks show up in force. They're there. But I'm just asking for this board to have the same respect that we have someone, when we ask for someone to come, that they would come, or at least communicate and say, we can't come ahead of time rather than in the board. So that's my take.
Yes, sir.
Judge Brown.
Well, I guess I've heard Commander Laura say about 4 times he's got answers for us. I'd like to hear his answers. We're just wasting time back and forth, and he says he's got answers for some of our questions. I'd like to hear what they are.
I'm going to get to Mr. Abdullah, and then we can hear from Commander Lara.
Yeah, from what I'm hearing, and I'm new, but from what I'm hearing, time is of the essence, especially when it comes to, you know, the questions that we have. And so if we ask a question now, we literally have to wait 30 days to get the answer to a question. And so one of the things I would like to suggest is that maybe, 15, 20 days before the next meeting, we can send our questions with our director and let her give the questions so that when you come back, you can come back to current, answer current questions that we're having as opposed to waiting a month and answering old questions.
Yes, sir. And we can do that. If you have any questions or concerns that you want us to address, if you go through Director Fitchard, we're in constant communication. And so anything that you have any concerns about, if you want to send to her, she'll get it to me. And as soon as she gets it to me, I try to get information as soon as possible to her so that she can get it back to the board. But I mean, that's something that absolutely, if you work with Director Fitchard on that, I can take care of that as best I can. Definitely, and get you the information before the next meeting.
So my question would also be, because I am would that need to be voted on here now, or?
You don't have to vote on it.
Okay.
Everyone I can facilitate the process.
Gotcha.
If everyone wants to send their questions to me directly.
Thank you.
Thank you, Mr.
We're talking about questions in regards to the recommendation. Is that correct?
Commander Lara.
Sure. Thank you. So there's, and I appreciate again the opportunity to speak to you all. There's a lot of different recommendations that we had here, and really I want to focus on the ones that were partial acceptances rather than the full acceptance. I know there was a couple of questions I'd like to address from the last meeting. I know Mr. Hayes, you had some questions about more detail on that de-escalation. I know you were talking about some other departments that have more information on it. And one of the way we look at it is we've got to look at the states are different. So some states have different laws, so they address things a little bit differently, especially use of force. But one of the things that we look at is we have our policies, which we write and we put together, and those are kind of our guardrails and our they're what we try to stay in between. But a lot of what we teach is really focused on the training. That's where the training academy comes in. So the policies are just the guardrails. And so de-escalation we've got a de-escalation policy, but we also have a lot of de-escalation training. For example, the verbal defense and influence that we teach at the training academy is one that all of the department was given. And so we take the policies and then we figure out what training best reinforces that training or those policies, that we have written regarding de-escalation. Again, we've had more de-escalation training than the state actually requires at our training academy. And so I know that that's something I'm hoping I'm giving you a little bit more information from your question. And again, you just asked, why do we not have more details in our training documents or our policy? Well, we have enough that we feel as a department, we have enough to get the point across of what we're trying to do, but we reinforce that more than anything with the training. I think that's where that we really take those policies and put them into play. I don't know if that answered that question that you had.
Yeah, I was saying that for example, I don't know if it was Baltimore, one of the cities of Baltimore, it just looked like it had a lot more detail, giving examples to officers so they can know what was being referred to in de-escalation. It seemed like Mnpd's was really missing a lot of that information. And I understand you say departments are different, yes, but I do think we need to be looking at best practices, and it looks like that was one of the cities that was best practices. So.
Oh, thank you. And what I say is one size doesn't fit all. You got to look at that state's laws, federal, state, and local laws. And so that's one of the things that we look at is their policies may work really well with their city and who governs them, but it may not work here. So again, our strategic development as well as the Metro Legal, they look through all of our policies to make sure that we are following the guidelines that govern us. And again, I guess for us, it's not just because you have a lot of examples written in the policy doesn't necessarily mean that that's going to change. I think making sure that the policy is strong and it has what it's needed and then reinforcing it with an actual training, that's what we focus on. Baltimore may focus on the policy itself. We focus on the policy, but we focus a lot on the training to make sure that we understand what the policy means. So again, that's why we have so many different de-escalation trainings that reinforce the policies, the de-escalation policy that we have. The de-escalation policy may not be 6 pages, 8 pages long, but it has the meat and potatoes that we need, and then from there, we really focus on the training to try to reinforce those policies.
But I was just saying, keep in mind that when it comes to policy, sometimes that's all the citizen has. I don't know what type of training you all have, but if a person can go online and they can look and they can see this is what the rules are supposed to be, they understand. But when it seems like when it gets to training, you can just say training, and a lot of times citizens don't know what the officer is expected to do and what they're not. So anyway, but thank you.
Yes, sir. I think another one that actually goes to one of the responses that we had, which Mr. Gooch had with the using the last resort verbiage. I think that's something that was brought up. And looking at that question or that recommendation and understanding that when you use the last resort, if I can see here where it actually said it on the on our response, it really focuses on if it's a last resort, then we have to exhaust every other step. So if you have somebody with a firearm that comes at you, you'd have to use every single step. You'd have to go and see if you can use a taser, see if you can use, hard empty hand control, all of these different things. You would have to go step by steps to each one of them when that would not be feasible. There's times when you have to go straight to whatever use of force is necessary at that time in that situation. And so when you look at a last resort, the last resort verbiage would be very difficult to follow because it puts people in danger if you have to go through each one and not resort to the level that is necessary in that specific situation. So I don't know if that helps, but again, that I know that others use that verbiage, but when we look at what the verbiage actually means, it means that you have to go through every step and actually exhaust every step, when sometimes that's not going to be the feasible thing to do. You can't go through each one. I can't sit there and talk with somebody with a gun pointing at me and hope that they can talk them down. Sometimes you have to escalate to a higher level of force depending on the situation itself without exhausting every step. And again, that's what last resort really means, is you have to exhaust every step before you get to that level.
Thank you for that, Captain Laura. I guess my question then would be towards Dr. Villier around the idea of the recommendation, what it's supposed to do, and just best practices when it comes to actually naming that we want if deadly force is going to be used, then it's going to be the absolute last resort. So I just wanted you to speak on that real fast.
Yeah, absolutely. So we based our recommendation based off of other cities' policies that use the language of last resort. And in discussions following the response, we disagreed with the implication that it would require every escalating step. For instance, if someone had a gun, you would be required to use a baton. That I don't believe that would be accurate. And that's not what other cities and multiple cities have implemented a policy using last resort language. The language was included specifically because it is moral language around the fact that use of force policies and using force should be a last resort. That protection of life is a fundamental part of what policing does, and that's clear in the policies that is a value that the police department has. That's what it says at the very beginning of the revised use of force policy, that protecting life is fundamental. And because of that, that is why we included that language of last resort, that other options, if reasonably feasible, should be exhausted. And that was the reasoning behind the recommendation, and is why we do disagree with saying that every force level would be required in every instance where lethal force was used.
If I can respond to that. So our policies, it talks about any force used must be both reasonable and necessary. If you look at the policy, it states authorized employees are permitted to use only that force which is reasonable and necessary under the particular circumstances to protect themselves or others from bodily injury, and only after other reasonable alternatives have been exhausted. So it has to be, you look at reasonable alternatives. What is the situation that you're presented with, and what are the reasonable alternatives that we can exhaust? And only after other reasonable alternatives have been exhausted, or it is determined that such alternative actions would be ineffective. So we're pretty much doing the same thing. This is a last resort in a one. It's just worded a little bit differently, but it's telling us we have to go and figure out what are the alternatives that we have, the reasonable alternatives in the situation we're found in. And if that's those actions would be ineffective, then under those circumstances, we could go ahead and use other force. When the use of force is needed, if feasible, we identify ourselves and do everything we need to do. It says, authorized employees will identify themselves and determine which options in the force continuum will best de-escalate the situation in the most safe, reasonable, and prudent manner possible. So the wording may not be last resort, but that's what we're doing. We're making sure that we're exhausting every other reasonable alternative before we use any type of deadly force or anything in that in that scale. We're working our way up. We're not just going straight for our weapons. We are trying to figure out what's reasonable in this situation. One thing may be reasonable right here in this one situation, may not be reasonable in the next. And so that's something that the officer has to determine through the circumstances that they're found in the training that they have. So I don't know if that, again, it's not the exact wording of last resort, but it's leading to the same outcome.
Yeah, and I think both of you all answered the question. And for me, I guess, you both are saying the same thing. So for me, I guess, what's difficult to compute here, that if the language of last resort would mean that an officer would need to go through every circumstance possible before escalating to last resort. And I know that's not what Dr. Valeri is saying. It's a moral statement. And then at the same time, the statement that exists already is already saying that they're going to use last resort. Why not just include the language in the manual already?
And again, so going to what the department sent, also, it's the guidance that it says here, instead of absolute language requiring last resort, Mnpd provides guidance that requires all other reasonable terms of force to be exhausted or determined to be ineffective. So to change the language in a policy and have an officer come up with a new understanding and have to retrain everybody, we use the same thing. We're trying to change something that doesn't need to be changed, I guess you could say. We're already covering the last resort by the verbiage that we're using. We don't see as a department the reason or a reason to go and change the verbiage just because somebody else is using that verbiage. As long as we're coming up with the same outcome, we're not going to use deadly force unless it's the ultimate last resort that we have. Our verbiage is saying the same thing, it's just worded a little bit differently. But again, if somebody's verbiage changes, are we going to change every time somebody else changes their verbiage and they come up with something better? Are we going to do that? I don't think we, as a department, we are looking to continue to change, to keep up with everybody else, as long as we're getting the verbiage that is necessary to fulfill the goals that we have, is to protect life and not to use any type of deadly force unless it's the absolutely necessary and it is the last resort and is reasonable and necessary within the circumstances that we're dealing with. So again, the verbiage is one thing.
Yeah, I want to be mindful of everyone's time here. Mr. Goddard.
I would just, Commander, I would take issue with the every time some other department does something. This is a recommendation from the Community Oversight Board. The citizens have vested with the authority to make recommendations. Doesn't mean you have to take every one, but this is not something that's going to come up and require changing and retraining this and that over and over and over. If the language says the same thing, I would suggest you take back, it's personal, unless the board wants to vote on it, take back and ask the department to consider going with the language that has been recommended by the board. We're not going to change it every month. We're not going to change it every year. And if it says the same thing to you, but it doesn't say the same thing to us representing the community, this board, not just me, but Lord knows, that's worthy of consideration. And I appreciate your response. It doesn't do much for me, simply put.
Yes, sir. So that's with that, and again, to respect everybody's time, I'll go quickly. Mr. Gwynn had a question with using early intervention system. I think it might have been answered. We are still using the early intervention system to keep track of any type of issues that an officer may have, keeping track if they're having a pattern of specific issues with force or complaints or anything like that. So that is something that we have in our HR department, I believe, is keeping track of that. So I hope that question there. One other question that Ms. McCree had last time about the 30 for 30. And so we are focusing on trying to hire highly qualified women And I think that's one of the things what we've done is we're changing some of our policies to help open up some of those opportunities for women. Just an example we had for the hijab for those who are Middle Eastern or Kurdish, other ladies, females who want to apply to the police department. We changed our policy so that they can use a hijab, which is the head covering, which is one of the things that we found out was keeping a lot of Middle Eastern ladies women from applying, because that's something that's in the religious belief they need to have it, and they didn't feel that they could. So that's just opening up a segment through some of the policies as well. One of the other things is our Deputy Chief of the Training Academy Administrative Services, Deputy Chief Loki, has been meeting with all of the females in the department. And one of the things she's doing is just trying to figure out what are the biggest obstacles that you have as women in this department to keep you from being police officers or to continue in this line of work. And one of the big things that just came out, just one point, was childcare. A lot of them are mothers, and they don't have the childcare to be able to take care of their children when they're working. So we're taking a lot of these. A lot of this information, and Chief Loki, as well as the department and Chief Drake, are figuring out ways that we can assist with this so it make it easier for more ladies to be able to have this opportunity to come in, so that we can get that 30 by 30, I should say. And so we're doing some female-specific recruiting that's in the works for the future. And there's just a lot of different things that we're looking at that hopefully we can get that 30 by 30 even sooner if we can. So just some things that I think that I'm hoping that answer some of the stuff that you had, some of the questions you had on that.
Thank you.
Thank you. One last thing, if I could. I know that we haven't addressed the specific policies, but one thing I do want to bring up is, and something that I think is important to understand when it comes to even our use of force policies and our use of force, how we're dealing with these events and how the trend is going. And this is as of August 31st, so this is almost a month out, and we're going to get new numbers now. In 2019, we had 288 force events. So that's 288 force events that were documented. In 2020, we had 200 force events, which is a 31% reduction from 2019. And so when you're looking at that, Chief Drake's commitment to de-escalation is proving to be effective. One last thing to understand is in the year 2021, this year, till August 31st, we have had only 91 force events. So at this rate, and this is, hypothetically speaking, if everything continues the way it is, for 2021, we can predict that we'll have about 138 force events, which is a 52% reduction from 2019. And I think that's goes to show that, the chief has changed things so that we are de-escalating, so that we are not having more force events. So instead of using force, we are getting out of these situations that possibly we could have used force in a different manner. We're ending them peacefully. And again, the reduction is clear. This is through our policy changes and also our training of de-escalation. Chief Drake has, constantly, pounded on everything, no more slow down. You need to slow down. We need to teach the officers to slow things down. Everybody gets so caught up in situations that they forget that they need to slow down and start thinking about other ways of dealing with them. So one of the things, again, that he's showing is that this commitment to de-escalation is working. You're over 50% from 2 years ago. I think that tells us something, that what we're doing is working, and we're going to continue to change things as we see it needs to be changed. If we need to add more de-escalation, we will. But again, it's something that I would like the board and the public to know that we're not where we were 2 years ago, and that we are getting better, and that the de-escalation training is working. And so that's just a couple of things that I wanted you to see. And if you have any specific questions, I'm more than happy to answer them.
Director Fitchard.
I just have a quick question.
Yes, ma'am.
As it pertains to recruiting and who's in those training classes, is there any way that you could give us a list of the breakdown of the demographics, gender, race? I know that, of course, we came to your last class. I don't know how many people were in that one. And then, of course, you have a lateral class coming up, just so that the board has an idea of who is actually, in the classes, and then who actually graduates. And, if you could get that for us, that would be great. Sort of like how you did the body worn camera information that you send. That would be I appreciate that.
Absolutely. I'll get that to you, Director Pritchard. Also, if any of you all have any questions on some of these things that we brought up, you can go to the dashboard, which was created. I think we're keeping it up pretty well. So if you go onto the metronashville.gov website, our police website, you can go over there where it says dashboard and has several different different information on different aspects like recruiting, community engagement, things like that. And so I think that you'll be able to get a lot of information from going onto that website and going to the dashboard that was newly created. So, thank you.
Mr. Campbell-Gooch.
Yeah, I just had one clarifying question on those numbers about the force events. And this is also having to do with what we're about to talk about next. Do any of those numbers include soft empty hand control?
No, those are not considered, soft empty hand control is not considered a use of force for us. Again, if you're walking, anytime you put your hands on, walk somebody to a car, we're not going to consider that a use of force in the sense that we're collecting data for use of force. So that is something I can get you more information on if you need to. But again, I think that's something that Dr. Valliere is actually going to be reviewing and going over. So.
And thank you for that, Captain Lloyd. And if I can just clarify, when I say soft empty hand control, I'm talking about techniques that use pressure points, controlled takedown, joints manipulation, or simply just grabbing a suspect. So, and that's what I meant by soft hand control.
Yes, sir.
But I know that might not, yeah.
Thank you.
So, so the break point for the 108 is above soft empty hand control.
So a 108 we do if there's anything above soft empty hand control, or if there's a allegation of injury, or if there's an injury and you use soft empty hand. So it's not specifically soft empty hand, but we have other criteria for a 108. Again, it's anything above soft empty hand control. But if all I use was soft empty hand and there's an injury or an allegation of injury, we also document it that way as well.
So if you lower the trigger, in other words, if you put off empty hand control in the 108, say the 108S is what I think is what's being considered, then we should expect to see those numbers go up quite a bit, shouldn't we?
It would all depend. If you're considering me walking somebody to a car use of force, then yes, it'd probably go up. But we don't consider that a use of force because that's not something, and that's just an example. If I'm walking somebody to a car, if I have my hand on them, then I'm using soft empty hand control to guide them to the car. If I have somebody in cuffs and I walk them to the car, are we considering that a use of force? So again, for what we are keeping track of, that is not considered a use of force. Right. And again, from what Mr. Gooch said, and you're looking at there, those specific things that we consider are soft empty hand control. If we do all those things and there is no allegation of injury, no injury, then we're not going to do 108. If we're doing those things, that what he described as a soft empty hand control, and there is a injury that occurs, or there's an allegation of injury, then we will go ahead and do a 108 on that.
So, Doctor, you're going to talk about some of this, I suspect, aren't you?
Yes.
Okay. I'm good. Thank you.
Okay. Dr. Hildreth?
Thank you. As Dr. Valliere, as you talk about that on page 3 of your report, when you have the full definition, you state that the department manual defines soft empty hand control as, and I don't think Member Campbell-Gooch went far enough, so I'm going to read the whole paragraph. The use of physical strength and skill in defensive tactics to control arrestees who are reluctant to be taken into custody and offer some degree of physical resistance. Such techniques are not impact-oriented and include pain compliance pressure points, controlled takedowns, joint manipulations, or simply grabbing the subject. That feels broader than walking somebody to the car. And so I'm hoping that you will incorporate that emphasis into the remarks you're about to give us. Thank you.
Yes, we can move on to the report if you'd like. So following the discussion at the last meeting where we discussed recommendations, there was one recommendation that was made by both the Community Oversight Board and the Mayor's Policing Policy Commission, which was to lower the use of force reporting threshold to include instances of soft empty hand control. So as Professor Hildreth just read, the department manual in the recent revision defined soft empty hand control which was not in the previous version. And that does include pain compliance, pressure points, controlled takedowns, joint manipulation, or simply grabbing a subject. And it is a defensive tactic used to control arrestees when people are being taken into custody. So that definition is if there is no allegation when those are performed of an injury, that currently would not lead to a use of force report. So these are instances where a person is resisting compliance with an officer, and the officer has to use some level of physical strength or defensive tactics in order to take them into custody. So that could be controlling them to the ground. That could be using grabs and holds to try to get them into handcuffs, twisting their arm behind their back. Those are all non-reportable if there's no allegation of an injury. Because of that, during the Policing Policy Commission meetings, there was conversation of requiring a Form 108 for those instances. The concern is where do you put that threshold, right? So soft empty hand control by many definitions could be putting a hand on somebody to coax them to a car. That is some level of coercion if you are guiding somebody with your hand. That would not be considered a use of force, I think, by a community standards definition. And I think it's important to think about the types of definitions we're thinking about. And when I think about this, I try to think of what would an average community member consider use of force. And when we were reviewing other policies, one of the defining characteristics of when something is reportable is when it's in response to resistance. So when someone is resisting an officer and an officer has to use physical force to gain compliance or control. And so in developing this report, we looked at the largest 50 police departments in the country. We found 47 of the 50 departments had policies available online, and 51% of those departments required reporting threshold lower than Metropolitan Nashville Police Department, and required reporting of soft empty hand control tactics when taking somebody into custody in response to when there is resistance. Many of these departments call it a response to resistance report or some other phrasing, but in general, the majority of the largest 50 departments require reporting of soft empty hand control when it's in response to resistance. We also we tried to find some evidence of how common soft empty hand control is, because as the highest force in a use of force incident, we found several studies that said that it was more common than higher levels of force, which would make sense since these are escalating. And so we found 4 reports that included this, and in cities where they track soft empty hand control as a use of force when it's in response to resistance, between 1 in 6 to as high as 1 in 3 of their use of force cases or use of force instances are soft empty hand control as the highest level of force. So those would not be tracked by the police department, and so we don't have a full, complete picture of how often all these types of force are being used. So this led us to really trying to come up with recommendations that clarify the partially accepted recommendations from the Community Oversight Board and the Policing Policy Commissions that were not incorporated into the policy. And so we developed 2 recommendations. One that soft empty hand control techniques used to overcome resistance should be reported to an officer's supervisor and require a written report that's tracked by Mnpd. The supervisor should evaluate which reporting and investigation method is most appropriate given the circumstances and determine the appropriate form for each officer involved to complete. tracking of soft empty hand control techniques used to overcome resistance should begin by January 1st, 2022. The second recommendation gets specifically into the type of tracking mechanism, and this recommendation recommends that the police department develop a form that's similar to their 108F, which is the firearm display report, which is a short form in order to track these instances. So as many other departments do, many departments categorize soft empty hand control as a level 1 use of force, and then force above that, so less lethal weapons like a taser or chemical spray, would be a level 2 use of force, or hard empty hand control, which would be punches or kicks. That would be a level 2 use of force. So categorizing into these levels guides the investigation process. This was the recommendation made by the Community Oversight Board last October, was that there be levels of force that guide the investigation process. This recommendation reiterates that there should be a short form that's used to track these instances that does include relevant information about the incident as well as a narrative from the officer, but that it doesn't require a full supervisor investigation as the 108 form does. And the supervisor would be required to review that form and sign off that was the appropriate mechanism, that they didn't have any concerns, and if they did have concerns, could then instigate a more full review of that incident. And that's the second recommendation. We provide two different sort of options that would fulfill this, and one would be that the 108F for the firearm display could be combined with the other form in order to streamline some of this tracking. So we actually try to get into some specifics of how this could be implemented. And then the last recommendation that's in this report is focused on a potential recommendation to the Metropolitan Council. Since this recommendation was not taken, the board has had discussions around what are next steps when recommendations are not accepted. What are the next steps? And one of those conversations has been around recommendations to the Metropolitan Council. So this does offer a potential recommendation to the council if that's a decision that the board would like to also include that recommendation in the report. So we discussed this expedited report at the executive committee meeting, and I just want to remind that the process for an expedited report is that when there are time pressures on a report, so in this case, the recommendation is that the implementation would be by January 1st, 2022. And with that time constraint, the executive committee felt it was appropriate to approve the expedited process. So the process for an expedited report is that once the board issues the report for public comment, that there would be a public comment hearing. That would be a special called meeting that would be combined with the board's approval of the report, or the board's consideration of the recommendations for approval. The executive committee discussed whether to have a special called meeting specifically on this, or since there's a special called meeting already planned for the proposed resolution reports, that if the board decided to suspend the rules, those could be combined into having the public hearing on the report and also the proposed resolution reports. But that would require suspension of the rules in order to combine those together. And are there any questions that I can answer, or discussion on this report or the process?
Mr. Hayes.
Just like I did in the executive committee meeting, I just want to commend the staff on this report. It's an excellent, detailed report. And I do believe if implemented, it will go a long ways in terms of showing where there are problems with specific officers before they do have to use deadly force. Thank you.
Any other questions for Dr. Villier? Mr. Goddard. Your microphone, Mr. Goddard.
Eventually, I will sound like one. The recommendations specifically talk about use of soft, empty hand control techniques used to overcome resistance. And then, but the Metro ordinance just talks about reporting use of soft control. Did you mean to have a distinction, or should that language to overcome resistance be added?
Yes, thank you for bringing that up. As we reviewed the draft after we had sent it, we did include that additional verbiage.
Perfect. Okay.
in the ordinance section in the definition of physical force.
Okay. Thank you.
Mr. Campbell-Gooch.
I didn't notice, kind of like similar, I didn't notice, and I might have overlooked, but is there any reference to the Community Oversight Board and either of the recommendations when it comes to the tracking or the response in the ordinance?
Yeah, so following the conversation with the executive committee, we did include reporting in the ordinance section, sending the report to the Community Oversight Board Executive Director, as well as in the recommendation, we do include that MNP provide COB database access to the new form as consistent with the current access that we already have to Form 108, 108T, and 108F, which we currently do access.
Mr. Nguyen.
Yeah, Doctor, I wanted to ask you about the burdensome paperwork that you'd have to fill out as an officer. So you're saying it would be a shorter form than the longer 108 that's filled out on the higher uses of force?
Yeah, so that is the recommendation, that it would be a shorter form. We want to take into account that we don't want to overburden officers with paperwork. And currently there's a firearm display report that is a short form that is required anytime a firearm is pointed except by SWAT members. And that is the short form that we were basing this recommendation on.
And the sergeant signs it, they collect it, it goes in the officer's personnel file?
The sergeant signs it, as well as members up the chain of command sign it just to give it approval. But it does not require a full investigation, including witness statements and interviews and corroborating evidence and photos. And
right. So would you think then it would be a benefit for the officer to fill out one of these forms on this kind of force, considering a year later someone says the officer did this to me, and they're looking for documentation of it and it's not there? So if the officer fills it out, in fact, it should help with liability management
I think
for that individual officer.
Yes, I think that's correct. I think that having documentation would help both the officer and the city with liability concerns around if there are lawsuits related to someone saying that force was used, but there was no documentation.
Right.
And this has come up from other oversight entities as well, and was discussed at a NACOL meeting, where there often are complaints of excessive force that won't meet the definition of use of force by the department, and that could potentially open up concerns around liability.
Right. So the COB is involved in liability management for the police department in a way. There are tax dollars as well.
Absolutely.
Right.
I think it is important to consider, how liability concerns for officers
right.
and for the city, and also to make sure that there's appropriate tracking so that people can file complaints, that there's appropriate documentation. Right. It could improve accountability and transparency, as well as management. And so I think this is another aspect that I didn't touch on. But for the management of the police department, this seems like a very important tool. Whether it's use of early intervention systems, early intervention systems can use this information as an early warning system, as part of the early warnings. Right. So uses of force are already entered into predicting a risk score for officer misconduct. And more information on these lower levels of force could potentially catch an instance where there might be some escalation, where an officer might need wellness assistance or have other concerns that might not be leading to higher levels of force, but they might be rougher than other officers in their unit, or they might be resorting to tactics when they could be de-escalating. And I think a supervisor being able to see this information and have that information would be able to use it to better manage and be able to help guide their officers to be better policemen,
Right.
police officers.
You aware Louisville is now under a civil rights investigation from the Justice Department?
Yes.
Have you looked at their reporting requirements for their 108S or whatever they label their
We have.
documentation?
Louisville does not require reporting, but many other cities similar size to Nashville do. So Denver, Colorado, Memphis, Charlotte, Mecklenburg, Austin, Columbus, Ohio, San Diego, Honolulu, Memphis, Detroit, Baltimore, Dallas, Houston, Philadelphia, and Chicago,
Right.
as well as others, right? So this is actually a very common requirement. In other cities, it hasn't produced an extra burden on officers. And in other, regarding firearm displays, which are often joined with this policy,
Right.
there's research evidence that shows that it actually could reduce the amount of shootings and unnecessary force. So having appropriate tracking mechanisms at all levels of the use of force continuum, I think is imperative to really being able to fully understand both what our community members are experiencing, but also what officers are experiencing. Because we don't have a full tracking of the resistance that officers experience.
Right.
And this would provide a more full picture of the situations where officers are meeting physical resistance from community members, as well as what community members are experiencing.
Right. Just to be clear on Louisville, the Justice Department's looking at patterns and practices of excessive force. And you're saying that they don't track their open, empty hand force options in arrest. Is that right?
They have not, according to their policy.
Thank you.
Any other questions for Dr. Villier? If not, I think the next step is to move to suspend the rules. Is that correct? Can we get the next steps? After, what happens after we move to suspend the rules? Sorry.
Then you can bring it up at
So there's two parts. One is to issue the report for public comment, and the second is to suspend the rules regarding scheduling. So I believe that could be done in the same motion. I believe, but I'm not the lawyer, so.
Yes. Efficiency, 2 in 1.
Does anyone want to make that motion?
Do you have a suggested form of a motion?
Yes.
Don't go to me. I'm not the. So I think and correct me, but I believe this motion to suspend the rules, and then a motion to approve the report for public comment and schedule it at the PRR special meeting. I believe. I'll ask the lawyers on the board and to make sure that's correct.
I'll move to approve the report, to consider the report at the special meeting scheduled for the PRR considerations, and to suspend all rules necessary to accomplish that.
Second.
Thank you, Judge Brown. Any focused discussion on the motion? There's none. All in favor, say aye.
Aye.
Any opposed? Motion passes. So we will then issue this for public comment and hold the public comment at our specially called meeting for PRRs. That's correct.
And I need to probably jump in and tell you when that is, right?
Yes.
Okay. So I have found the date for the special call meeting to hear the reports that we have outstanding, or as many as we can get in that day. I think we have 9 reports that are out, that are ready to go. I don't know if within a 2-hour time frame, if we would be able to get 9 done. So my suggestion is to get 5 done. And then the remaining 4 at the next regular board meeting, but you guys can determine that. The special call meeting is going to be set for, if this date works for everyone, Wednesday, the 13th at 5 p.m. And that was confirmed with Metro Network, as well as the room here would be available at 5 p.m. There wasn't any other dates that week, but if that doesn't work, we can move it to the next week. It's up to you all.
Any preference there? I think we should schedule it as early as possible. So then our meeting will be on the 13th at 5 p.m. Yes.
All right, correct.
All right. I think Mr. Yoon.
Yes, thank you. Sorry, I'm trying to do the thing that it seems like everybody's been doing.
Can you turn on your microphone?
I did want to, while people were checking schedules and confirming that, just give a response to Board Member Campbell Gooch, who asked me earlier what the board's legal options were for any perceived non-responsiveness, disappointing, or otherwise from the Metro Police Department. I punted the question because I don't like to get a question and then give you the wrong answer. But as I was reflecting upon it and looking into the memorandum of understanding that Commander Lara brought up, there is nothing that says COB, the police department shall appear at meetings and things of that sort. That's certainly something that you can do. But there are also things like demand letters that the board can obviously write to the chief of police to sort of encourage him to be responsive or to appoint someone to do so. You would also be able to point to the MOU as far as the Mnpd officers want to have a cooperative relationship with the department and the COB. So that would certainly qualify as not in the spirit of or in the letter of y'all's MOU, that they are in violation of that memorandum of understanding. And finally, this board does have subpoena power. While it has only been envisioned for an actual investigation into misconduct by a single police officer that's been brought by a complaint, we could explore options such as asking the council to subpoena the chief of police or one of his designated representatives to a board meeting of the COB for that specific purpose.
Thank you, Mr. Yoon. And if there's no more discussion on that, we can move to public comment. And we have Mr. Tucker signed up. You have 3 minutes.
Three minutes, that's all. I appreciate it. I've been watching the development of this board ever since its inception, and I am constantly amazed and surprised by the work that you continually put in. But it's also as though I've been watching a chess game of 2 pros, and now there are about 4 moves left that will determine whether there'll be a checkmate or there'll be a draw. From the very beginning, the people of Nashville voted clearly for community oversight of the police department, not cooperation. So the police department is going to constantly push, just how much do I have to cooperate? The MOU, I believe, from the beginning, set up this trajectory, which could have been better handled by an executive order by the mayor telling the chief that he will report to the Community Oversight Board, which the voting folks of Nashville overwhelmingly said, we do not trust the police department to run themselves, so we will select a group of citizens to provide oversight. At some point, the city must make some adjustments to its current statutory things that allow this to persist. Because for me, I don't understand of why the people's will has not been met or tried to be met more earnestly. I appreciate all that y'all do. I appreciate Dr. Filchard going back and forth, back and forth, back and forth. Because what it does is, you're right, 30 days, another 30 days, another 30 days. Then all of a sudden, as one of the commissioners aptly said, well, I'm a little bit in a kerfuffle about disciplining somebody after 18 months, because it ought not be that way. And so I know that others that I spoke to feel this way, but the other issue I also wanted to bring up is the release of the body cam footage. After we finally got the cameras, after 3 years of being approved and whatever of being deployed, the arbitrary cut and paste and narration that is going out to the public is not acceptable. I'm horrified when I see Don Aaron stand up like the guy on America's Most Wanted and tell me to beware what I'm going to see, may be offensive or whatever. But then they have picked a soundtrack to that. Who picks the music in the Mnpd that is appropriate for the cut and paste of the body cam footage? What we're getting is not what we paid for. And I just want to bring this up again to you, because many of you already know that. We want the body cam footage in a way that allows an average citizen to make an assessment of it. You don't need the narration. You damn sure don't need the soundtrack. So again, I appreciate the work you do. I really do. And again, you just set up to have a second meeting in the middle of the month. Some of you are working and all of that. I appreciate that. And I ask that you not give up, because the citizens of Nashville who fought hard to establish this board, we really are depending on you. Thank you.
Thank you, Mr. Tucker. And that concludes the public comment section. Any new business or announcements?
I thought there was another comment, Ms. Pitcher. You
Do I
should
have
gotten
that?
an email.
Can you read that?
This is a public comment from David Lee Myers. It was emailed. Hello, I'm writing this email with respect to the Oversight Board hearing on September the 29th with specific comment towards license plate readers. Unfortunately, my work hours conflict with the board meeting and I will not be able to attend in person. I'm writing to speak with vigorous condemnation against anyone who is pushing LPRs in any aspect of the Nashville community. I'm against LPRs whether they come from Nashville's or another entity's budget and funding. LPRs only serve to increase the power of state surveillance on ordinary people and all around grants more power to a police force that routinely abuses its power and fails, like most other police departments, to make communities safer. I am more deeply concerned with the disproportionate effect that this will have on Black, Latinx, and West Asian and North African communities currently residing in Nashville. It doesn't take a genius to recognize that police departments are riddled with racists and those who have little problem with racism overall. Rather, it takes someone very deluded to deny that there is racist enforcement of the law. I am certain that, if passed, there will be an incident in Nashville where the police will use LPRs to track down and needlessly kill someone over a minor infraction. I have zero confidence in this city's police department, and anyone who would argue that LPRs keep Nashville safe and hope the parties advocating for such a policy feel deep shame and reconsider their asinine proposal.
Thank you, Director Fitchard. Mr. Hayes.
And I don't know if you're missing that, Director, but there was another one from Ms. Melissa Cherry, an email, and she said she had to leave, but she wanted to leave comment. But she copied 2 board members on it.
Okay, okay, I see it. Thank you. I'll read that as well. Director Fitchard, I do have to get to another meeting, but would love to submit comments from the board meeting for presentation when it's appropriate. My comment would be that I'd like to hear more about the COB's ability to review OPA cases in light of the track record that created the COB. Is there a process by which they could audit all OPA investigations? I think it needs to be said that we keep mentioning public education around the right to refuse a search, but I'd post that the residents of this city know exactly how MDHA operates and that they do feel a credible threat to their housing. I wonder if there's a possibility to have a training for MDHA about the impact of this to their community. And I would second the recommendation to track and research patterns of complaints by officers, and additionally complaints about voluntary consent at MDHA or subsidized properties. Lastly, I'd like to second the assertion that the actions of Mnpd not sending anyone but their assigned liaison to discuss these important recommendations was disrespectful and continues a pattern by Mnpd. Additionally, Commander Ramos, Lara, minimizing of the COB through his comments about changing wording in the training manual were reflective of the position of Mnpd on balance and incredibly disturbing as a resident that values the role of the board as the representative of the community. Thanks so much for your time. Melissa Cherry.
Thank you, Director Fitchard. Mr. Campbell-Gooch.
I know we're on our way out, and I know we're in new business and announcements. So I had a really quick announcement to make to board members. I know many of you, I could just say are my friends. You know, a lot of you, we've worked in the past outside of here, but I just wanted to make an announcement that earlier this month, I transitioned away from Gideon's Army. And with that being said, I think recently, with all of the things that come to light, there's been a fundamental misunderstanding about what violence interruption is. So if board members can just go with me real second, I got 3 very specific things. We know violence spreads like a disease. We know that. It pools and it spreads through contact with community members over and over again. And when I say violence, I mean any form of intimidation, whether it be with a weapon, with words, any type of thing like that is violence, and it spreads like a disease. And the way we interrupt that transmission of that violence is through credible messengers, people that we know. Everybody does not have the same one, but we all have someone we can talk to literally calm us down, slow us down, and interrupt the transmission of whatever violence that we are experiencing. But the person who is the credible messenger cannot be associated with any type of institution that is committing violence into our community. So that is both official institutions and community members that are both committing that violence. And then thirdly, we need violence interruption from a high level, from a government level, because it is a population of people that I have to constantly bring up that do not call the police, but deserve safety from folks that are constantly doing our community harm. So I want to say very succinctly again, 1, I'm no longer with Gideon's Army, but that does not change my dedication to making sure violence interruption is available to every community member across our city. So I just wanted to make that announcement here and also open myself up if there's ever any questions about what violence interruption is. both nationally and what it could look like locally, funded via our city budget from the official government. I'm open for any questions anytime.
Thank you, Mr. Campbell-Gooch.
And Chair, if we have a moment, there is one additional public comment. She raised her hand. I don't want to miss the opportunity to hear her if we have the time.
It's my first meeting, so I'm sorry if I didn't sign up somewhere where I
It's
was
okay.
supposed to. I just wanted to say that I support you all, and I don't want to take up too much of your time. I know we're running over already, but I thank you for the dedication that you do have to our community and to holding Mnpd accountable. I wanted to say that I am curious if the disciplinary action grid for detectives is public information, and if it isn't, to request that it is. In general, I'm in favor of more public information. So I really look forward to seeing what type of education the outreach liaison will bring to the community. And I wanted to respond to Commander Lara's question, asking, are we going to have to change our verbiage every time another police department changes theirs? I think it's absolutely important to change verbiage and policies based on research from this Community Oversight Board or any community or state or federal levels proving that certain verbiage or policies for police departments, reduction of police brutality on the community that it's serving. And yeah, thank you all.
Thank you.
Thank you. And I'm not going to let you leave until we have some volunteers to form a nominations committee, because I've said it for the past 3 meetings and we still don't have a committee. So nominations committee. Our terms, the executive committee's terms are up in January. So we need to have people nominated for the next positions soon. So who would like to be on that committee? Okay, Mr. Abdullah. There's one. Mr. Nguyen?
Mr. Nguyen, okay.
We'll take a few more.
Judge Brown, you want to be on the committee?
Okay. All right. Mr. Abdullah, Mr. Nguyen, and Judge Brown are going to be on the nominations committee so far. Does anyone want to take ownership and be chair of that?
I nominate
If
Mr.
not-
Nguyen.
If not, Director Fisher, can you facilitate the first meeting?
Yes.
So that we can elect a chair there.
I got it.
All right.
I do have one update before we close out.
Okay.
And I didn't talk about the email that I received from Councilmember Porterfield in regards to reporting for the CIT, the pilot program. And just to give you a quick update, the police department has a new pilot program that they have kind of coupled with mental health co-op to provide a service to our community regarding a co-response model for mental health calls for service. And I had asked the liaison from the mayor's office, Ms. Diaz-Cirillo, to give me some update on it. As I checked in with her at that time, it was still fairly new. It was like a month and a half in. I think that was in August. And at the time, she did not have any numbers for us because they were still trying to formulate their numbers and get correct information. She said that there would be a quarterly report that came out, and we would get the information in October. So I've been waiting on that, which is not something that I checked back in because I was waiting into October. But Councilmember Porterfield has is issuing an ordinance regarding the reporting, and she is wanting to have the reporting on this program because of the funding that it receives monthly for the council members, and she wanted our support of that, so that we would also get the kind of report, that we would also get a report as well as the council members. And so I sent that to you all, and what she's actually wanting is the same things that we would ask for: how many calls for service, the number of the calls that were diffused without police intervention, the number of calls that required police intervention or detention or arrest. And then there's some other important information that she's proposing. And so I did want to say that I agreed because I made the decision because I thought that she needed it right then. And I said that I was in fully support of that. And so I just wanted to make certain that you all were aware of that. And so that's it.
Thank you, Director Fitchard. If there's nothing else, I'll take a motion to adjourn.
I second that.
Well, we need to make a motion first.
I move to adjourn the meeting.
I second.
Thank you. All in favor, say aye. Aye. Thank you, everyone.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.org.